Good morning. This is the Colorado Oil and Gas Conservation Commission. It is Wednesday, February 22nd. Hope everybody is staying warm. We have an agenda this morning, our business agenda. And before we undertake that, we will take a roll call of the commissioners.
Thank you, Mr. Chair. Commissioner Ackerman.
Here.
Commissioner Bogue. Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Great. Good to see everybody. We have a slight agenda. The first is unscheduled commissioner comments. Does any commissioner have comments for the rest of us and or our stakeholders who are listening in? All right, seeing none, our next agenda item is the consent agenda. We have 3 hearing officer recommendations. Does anyone have questions or thoughts about consent agenda? All right, seeing none, do we have a motion to approve consent agenda?
So second.
Motion from Commissioner Cross, second from Commissioner McGowan. Further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. So the consent agenda is approved. We now will move to docket 2202-00034. This involves a variance request from Renegade Oil and Gas Company, LLC. I believe we will hear from the attorney for the applicant to begin this matter. Good morning, Mr. Campbell.
Good morning.
Good morning, Mr. Ingve.
Good morning. Let me see. Technologically, hang on. How about now?
Yes, we can hear you now very well.
We're hoping we don't get too much feedback. We're all kind of in the same room, so we'll see how this works for a little bit.
And Mr. Ingve, we are getting feedback. So we could hear you not real well when you first spoke, when you're on mute.
Let me, so I was too soft, or you were just, it just wasn't coming out across clear?
When you're on mute, you were fairly, it was a little difficult to hear. We can hear you well now. And I think if the other, if all 3 folks are in the same room, if the 2 that aren't speaking are on mute, we might be able to accomplish this easily.
Correct. That's kind of what we anticipated. So I will go back to mute since council will be first up.
Are we ready to proceed, Mr. Chair?
Yes, Mr. Campbell, we're ready to proceed.
Good morning, Mr. Chair, commissioners, and staff. Thank you for hearing this matter today. My name is Scott Campbell of Post Nodell and Peterson, and with me today is my co-counsel, Rob Willis. And on behalf of the applicant, Renegade Oil and Gas Company, LLC, we have Ed Ingve, president and owner, and J.B. Condell, vice president of land and CFO. Renegade has submitted an application for a variance from the combusting limitations under Rule 903D3 of the Commission's rules for 47 stranded wells with low GOR, gas oil ratios, located within a 900 square mile area covering parts of remote Adams, Arapahoe, and Elbert counties. Renegade's evidence will demonstrate to you this morning that it has made a good faith effort to comply or is unable to comply with the requirements contained in the Commission's rules, that the requested variance will not violate the basic intent of the Act, that the requested variance is necessary to avoid an undue hardship. Granting the variance will result in no net adverse impact to public health, safety, welfare, the environment, or wildlife resources, and that the requested variance contains reasonable conditions of approval. And on these elements, we would point out that Director Murphy and your staff have already recommended approval of the variance, along with recommended reasonable conditions of approval. Finally, Renegade has raised a number of other legal issues which we believe are moot if the variance is granted. So it strikes us the most efficient use of our time here this morning is to proceed on the merits of the variance application and discuss other issues only if we or the commission finds it necessary. So with that introduction and your permission, Mr. Chair, we're ready to call our first witness. And although we believe Mr. Ingve will be the only witness, it's possible Mr. Condell may have some testimony as well. So perhaps we could swear them both in at the same time.
Okay, let's stop the clock and let's bring AAG Davenport to the table for the swearing in of witnesses.
Thank you, Chair. Mr. Ingve and Mr. Condell, I'll start with Mr. Ingve. Sir, all I'll ask you to do is raise your right hand and state your name and say that you swear to tell the truth.
I, Edward Ingve, swear to tell the truth.
Thank you. Mr. Condell, same thing.
I, JB Condill, swear to tell the truth.
Thank you.
And
Gentlemen, I'll hand the reins over to you.
Uh-oh. Oh, there we go. I was confused. Yeah, should I turn up my volume? Probably. Well, maybe not. That's just speaker volume. Okay. Good morning, commissioners. Like I said, I am Ed Ingve. I am owner of Renegade Oil and Gas Company. Go through our little slide presentation and augment it a little bit, but I'm guessing most have already seen a lot of this. Give you a little history of Renegade. Renegade's been around for over 35 years. I acquired my first well, actually back in 1986, but it wasn't under Renegade. So I've been doing I've been doing this for quite some time out here, and have been operator predominantly in the Eastern Colorado area. During that 30 years that Renegade's been around, we've grown fairly dramatically, especially early on through acquisitions. I've done a limited amount of new drilling, re-entered quite a few wells that previously were plugged. And at one point, our portfolio of wells was up to 185. I should make a comment that we had very few non-operated properties, and most everything I have, I own 100%. History, on May 1st of 2018, we had 179 wells. This was all prior to my world come crashing down, but I was an operator in good standing with the Oil and Gas Commission. And I was both fully bonded for all my producing and in excess inactive wells at that moment in time. Next slide. On May 31, my world kind of came crashing down. Anadarko, Kerr-McGee, Western Midstream, Occidental, whatever subsidiary you want to refer to, we'll just call them collectively Anadarko at this point going forward, shut down the Third Creek gas gathering system east of the metro area here. Renegade was highly dependent on that system. In fact, a lot of the acquisitions that I made, we actually removed from what now is the Renegade Wattenberg system and placed on the Renegade Third Creek system for line pressure purposes and advantageous, or to help the wells out from an advantageous engineering standpoint. Just as an aside, at the time that this system was shut down, Renegade was in final negotiations of a 10-year contract extension with Anadarko. Prior to the shutdown, Third Creek was gathering gas from hundreds of legacy D&J wells out in this area, and the footprint of the system covered over 900 square miles. Next slide, I'll highlight a little bit. This is the map that we kind of have been using. It can be a little bit confusing, but I can highlight a few things there. The Third Creek system predominantly is the green pipe, along with the very dark red piping. The dark red piping is their high pressure piping, and the green was kind of their gathering piping, and they had several satellite compressors out there. The light red is to highlight is some new piping that has shown up generally within the last 2 years, but is being built to service some of the horizontal activity that's occurring. The yellow dots that you see are the locations or tank batteries that we're requesting the variance from, which is only a small portion of Renegade's portfolio, but those are the tank batteries, and then the wells behind them are constitute the 47 wells. Next slide. What happened when my world came crashing down? Well, we tried to come up with anything and everything that we could think of, and some of you guys have been around long enough that I'm not new to this arena at the Oil and Gas Commission, but we tried to come up with everything that we could, and I might even add to a certain extent that waiting it out was a viable option, or seemed like a viable option also. I don't know if you remember or recall when Oxy purchased Anadarko, they immediately put the midstream company up for sale, and we were crossing our fingers and really hoping that with a new owner and new blood that maybe the outcome for Third Creek would be different. From an operational standpoint, I immediately had to cut some staff and reduce costs as much as possible. We started evaluating what the suitability was for combusting at wells in particular, or leases that we had that had low GORs. We identified, several of these leases. Most of those are the ones that we're requesting for today. We filed the necessary paperwork at the Oil and Gas Commission, spent hundreds of thousands of dollars. That was actually kind of encouraged at that point in time, not too far back in 2018, as the alternative procedure from the Oil and Gas Commission's perspective that would allow me to at least hang around and keep producing some wells. The higher GOR wells, which tend to be mostly more in the Adams County area, are still shut in and remain shut in. Legally, we started trying to come up with avenues and ways to pursue, and we, at the recommendation of the Oil and Gas Commission, we filed an action at the Colorado PUC, which we were not successful. They actually remanded it back to you guys. And we also filed a lawsuit against Anadarko in Adams District Court. I was the nucleus of trying to gather support, not only from the Oil and Gas Commission, but from the other producers out on the system, and trying to advance collaborative efforts, hoping that many would be better than one. We tried to talk to anybody we could, including local officials, elected officials, predominant people, trade organizations. And like I said, we were scrambling, needless to say, to try to figure out what to do. Next slide. One of the remedies that we came up with was we tried to collaborate and see if we couldn't collectively buy the Third Creek system from Anadarko. We had interest in doing that, and given that it would at that point in time just be a big liability for Anadarko, we thought they'd be open to that. We also identified other people that are in that midstream sphere that would have loved to buy the Third Creek remnants, and so we did some introductory type of work and background type work with several parties, trying to tell them what was out there and how much production we had. Unfortunately, on the bottom there, you can see that Anadarko kind of rejected everything. I think this was largely as a result of the Firestone situation, but at least that's what they've kind of made representations of. And they kept the system around for about 2 years or so after that, but they have now, for the most part, physically abandoned the system. Just as an aside too, we did at one point have a little bit of a glimmer of hope in the middle of some settlement discussions about where maybe they would consider at least transferring part of Third Creek. So we've been teased several times as to maybe there's a way to try to put Humpty Dumpty back together again a little bit. Next slide. Things that we looked at, not just for these particular leases in question, but for a lot of the other shut-in wells that I currently have, is we explored generating electricity on site and selling directly into the grid, talking to both Excel and the REAs out there. It just was too unwieldy. The system for small scale generation at the type we were doing wasn't going to work. The economics weren't there. The cooperative nature of the parties really wasn't there either. We looked at possibly treating on site, both for liquid extraction and natural gas liquefaction, and see if we could make that work. But once again, the volumes tend to be too small and too dispersed over that area to really make that have any sort of commerciality affiliated with that. We looked at on-site generation. This was when Cully Cavanis with Crusoe was just starting his company, and that was kind of becoming the hot item. And we explored that. And once again, to a large degree, at least at the outset of that kind of concept, once again, the volumes didn't justify it. We couldn't aggregate enough volume in one spot to make that work at that point in time. Next slide. Obviously, some other things that threw us a bunch of curveballs. Obviously, the rulemaking and Senate Bill 181 was pretty devastating, especially to small producers, small operators, people with my business model. I think that kind of has played out, as you can see, just in the state, and how many small operators have gone away. Obviously, the COVID pandemic and the associated price crash didn't help. We can't rebuild this thing. There was no economics in rebuilding Third Creek. It's just not an option. You've got an older system out there that services older wells, and putting a new modern system in it wasn't going to cut it. And I would still qualify impediments right now is, we're still not really done through the whole rulemaking stuff. Got financial assurance rule hearing coming up in April. And I'm still very uncomfortable to see how that may or may not play out. I could also add another impediment to success, and that was that Anadarko never sold the midstream unit, unfortunately, largely due to some of the other stuff in that nobody wanted Colorado assets, and then the COVID and the price crash kind of allowed that not to happen. So how did we survive? How did Renegade survive, beside me just being very stubborn? I told you we reduced staff. We tried to produce the oil wells that combusted the gas, and combusted gas on the low GOR wells. We sold some assets. I personally mortgaged my primary resident and dipped into my retirement funds to kind of keep us kind of waddling along. And as a result of that, it should be noted that I am the last significant Third Creek operator that has yet to disappear or go bankrupt and turn wells over to the state's orphan well program. Where are we at now? Well, as we sit today, I'm still viable. Commodity prices have helped, and that's allowed us to generate at least some small positive cash flow. We've instituted a pilot program, which has received a lot of news coverage, unfortunately, but to use some of the smaller size, newer data centers, the crypto mining type activity. We've tried to implement that on a few sites. You probably have read or seen that those activities were aggressively challenged in Adams County as not being conforming to their zoning laws, and to a certain extent by Arapahoe County also, but they just have not been as aggressive. We're still trying to beat on Anadarko's doors. I don't know how many times, we've made contacts with Anadarko personnel at different levels to try to see if there isn't ways to shift some of the Third Creek wells back over to the Wattenberg system, which they currently operate and still is, to this day being utilized to collect a lot of other people's production out there, in particular some of the horizontal activity. But it's, you know, we've been frustrated. Most of the parts referenced in that bullet point, though, are shut-in wells. They're not necessarily the wells subject to this variance. We were exploring the possibility of language within the act with regard to rateable takings and see whether that's an avenue or not. As I did point out on the slide, there has been some new development activity out there, mainly servicing the horizontal stuff, but could be used for at least several of these leases that we're applying for in proximity to some of that new line. We are currently in dialogue with several of those parties, and we're advancing potential tie-ins for some of these new locations, not all, but some of them. So some of these some of these locations might not even need this in the not too distant future, at least is what we're holding our breath and hoping for. But that does point out, and you know, the second bullet point talks about that. Based on the map, these wells are spread out and locations are spread out over a very large geographical area. There is not going to be a one solution situation here. It's going to be kind of a piecemeal. There could be wells and leases, locations that could be tied into new infrastructure. There could be more deployment of data center crypto mining devices if we can get the local jurisdictions and counties on board with that. There could be wells that need to be plugged. We're still, one of the things that we are also doing is trying to now potentially take over some of the abandoned gas lines of Third Creek and possibly use that to now maybe aggregate some of the volumes that we have out there and possibly have new opportunities because of larger volumes presented to us and some of the impediments that I discussed earlier. So right now, what we're doing is we're applying for the variance. We're trying to keep as viable under the circumstances and hang around and just see if any of these strategies potentially could work down the road, and doing everything I can to try to prevent my wells from being dropped into the orphan well program. Highlighting, like I said, the 47 wells, which constitutes 22 tank batteries here. The GOR on them is pretty darn low. The 67 MCF a day I would represent as a fairly de minimis amount of gas. On a per location basis, you're looking at 3 MCF a day, maybe on your average location. You know, some are 5 or 10, some are 1 or 2. But I say the 67 MCF over 22 locations, 47 wells. I know from some of this crypto mining operations that I've been doing, that constitutes about what 5 or 6 SUV engines would burn if it was all concentrated in one spot. The GORs of the remaining wells that we have that are still shut in, and that constitutes over 100 Renegade wells right now, as you can see, is much higher. It's over 10-fold higher than the wells that we're discussing today. The next one is kind of self-explanatory. I'm going to let my outstanding counsel, maybe if you have questions about that, let him field that realm. But once again, I know there is a legal definition of waste out there, but there's also, I would contend, a layman real world definition of waste, and I recognize there's some legal aspects that might have to be looked at there, but I say, you know, producing of my wells will yield oil production and benefiting, you know, my not only Renegade, but customers, lessors, royalty owners. I think we've included in the appendix there at least 8 letters of support that we've solicited or we've gotten from impacted parties on these 47 leases or 47 wells. You know, to
Did we lose Mr. Ingve?
And if that well was sold down a pipeline, it would be burned at some point too. So regard to greenhouse gas effects and things of that nature, there really wouldn't be any difference. And I would contend that the actual waste, the real world waste definition, would be the non-production of that oil and the benefits that we derive from that production. Next slide. Next slide is just kind of a regurgitation of your rule and the 5 elements of what's required with regard to a variance. With regard to 502C1, I don't think you can not say that Renegade hasn't spent a good faith effort over 4 years of continually trying to find a solution out here that could potentially either get this well, this gas, either of the shut-in wells or on these producing wells, utilized in a different way or a better way than it currently is. You know, this was a force majeure type event. And then with all the other circumstances, which we've already highlighted, it's been a tough slog. But we have made some progress lately, and some of that has been the economics, some of that has been some rulemaking clarity, regulatory certainty. So I think there is reasons to think that there's a possibility of crawling our way out of here. 502C2, the basic, or is another part of the act. I'd highlight, you know, that the act directs the commission to regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts on public health, safety, and welfare, the environment, and wildlife resources. I'd really like to highlight on that. It says minimize, not eliminate. I'd also like to highlight it says reasonable in there. And I think that language clearly contemplates that there'll be places within the rules that need to be modified for specific circumstances. And I would suggest to you that those circumstances are the Third Creek situation as a poster child. I know that came up many times in rulemaking. There was contemplation about specifically the Third Creek situation and what's happening out there and the impact of the rules. You know, Renegade is operating its oil wells has resulted in production. To get the oil out, there is going to be some gas produced. There's no way to get around that. The geological circumstances surrounding these wells and the volatility of the oil produced, there's just no way around that you can just produce the oil and not produce the gas. So we have to deal with it, and we feel that the best way, at least as we sit here today, is through these 98% destructive enclosed combustor devices. Next slide. Yeah. You know, when Third Creek was shut down, it impacted hundreds of wells. We've seen different numbers from 400 to 500 to as many as 700. And most of those wells, it appears, will never be produced again. I know the commission, and it kind of tears me up because I know this area very, very well, but is aggressively plugging a lot of these commercial wells, or these wells that used to be commercial for no other reason except the lack of gas sales right now. You know, there's wells out there that, you know, are capable of producing very commercial quantities, especially for small operators like myself, if it were not for the Third Creek shutdown. And it just kind of tears me up. Unfortunately, every well that gets plugged out there, including what's going on the orphan well program, potentially makes it more difficult to try to aggregate volumes and come up with a solution for the remaining wells out there. But we're still in the game. You know, at present, with Third Creek being shut down and being abandoned for the most part underground, we're the last major sole survivor of Third Creek. And I will contend that the volumes that we're talking about here, like I said, are de minimis volumes relative to what I have shut in, relative to the definition of what de minimis is, and how much gas we're really talking. I just ask that, we given the opportunity to kind of pursue some of these alternative solutions. And I contend that that is not a violation of the act. 502c3, I would say, just to piggyback on what I just said, that I think the hardship here is that the denying of that variance would cause undue hardship. It would obviously make my life a lot more difficult, potentially jeopardizing employment that I not only of myself, but the contractors that I utilize, and possibly orphaning of wells. It also will cost royalty owners and lessors and the few working interest owners that I have out there. It'll cause them financial hardship. And you can certainly say that the tax revenue affiliated with the production that we have out there will be lost, and the public will not benefit either. 502c4, no net adverse impacts. This approval of the variance really is just a continuation of what we're doing out there now. It's just a continuation of the status quo. There will be no new impacts varying from the current situation. I don't think, I'll just leave it there. We probably should have thrown in a 502c5, which we didn't on the last part of the variance request. And with regarding to reasonable conditions of approval, at that point, I will highlight the staff's recommendation that they have agreed with our conclusion that approval of this variance is they're recommending it, and they have put conditions of approval affiliated with that recommendation, which Renegade is willing to accept. And there again, the language in 502c5 once again talks about reasonable, and I don't think what they're asking or what they put on there is unreasonable. So I'd highlight the word reasonable again. Jurisdiction over emissions. There again, this is more my council's arena, but if you approve it, this is moot. And the last is the last couple slides there, 25, 26, are more just the same as far as the legal advancement of the emissions.
So go ahead.
Yeah, I'll mute, and I'll turn it back over to him for a second.
Thank you, Mr. Ingvey. That completes Renegade's presentation, Mr. Chair. Thank you, everybody, for your time and attention. We're ready for questions.
Very good. If you want to stop screen share, that would give us a little chance to be able to see everybody a little bit better. Okay, commissioners, we have heard from the applicant. Does anyone desire to lead with any questions? Commissioner McGowan?
Thank you, Mr. Chair. And thank you, Mr. Ingvey, for being here today. And you and I have spoken several times, and you're a frequent flyer at the commission hearings. I'm wondering if you read Adams County's submittal to this docket.
Yes, I have.
I'm kind of interested in your thoughts about, a variance that has a limitation that gives you a chance to keep working on some of these options for beneficial use that you've been talking about. So I'm wondering what your thoughts are about that.
Well, I think there's some irony there. Some of the conditions of approval that they're suggesting, quite frankly, aren't aren't doable. You know, especially when they're referring to some of the financial assurance being 100% posted and things of that nature. A little bit of background, which there again, I didn't highlight a whole lot, but you know, they turned around and sued me. I was trying to come up with solutions out there to get some of these wells back online, and they didn't like the concept of, you know, a small scale generation and data center on a lease site and deem that a zoning violation. I would contend that it was not, but in the course of the legal action affiliated out there, we did kind of push them back. I have met with several of the Adams County commissioners. I think there is a disconnect a little bit with at least the commissioners and the staff. I know when the events first started happening all the way back, I believe it was last May, and we had dialogue with the staff. We were, you know, they said, well, give us a little bit of time and we can get something on the books. And they were targeting by the end of this year. Just for illustrative purposes, I have now just gotten the first notice of a potential rulemaking or stakeholders involvement for rulemaking with regard to their building codes here in March. You know, once things started to evolve, they pretty much said, oh, we can't do it in the 6-month time window that we did. We're going to be rewriting our entire building code and we're going to put it in with that. And we anticipate that it's going to take 2 years. And I said, I don't have 2 years. And there again, I think they're a little bit overstepped their bounds. I would contend that I think since it's an on-site use and it's on an existing pad, I would say that's your jurisdiction, not theirs. You know,
Well,
they were trying to.
I'm not trying to solve that problem today.
Okay, I'm sorry.
So I think I missed in your request for the hearing today, or I'm misunderstanding. Are you asking for a variance in perpetuity or a time-limited variance that allows you to figure out beneficial use for the natural gas from these 47 wells?
I don't think we placed a date on ours.
Right, so I'm trying to understand, are you just asking for a variance that works forever or a time limit?
I guess for these particular locations, I would, with the anticipation that, like I said, several of these will become moot fairly, you know, we're hoping 6 months, 12 months down the road. You know, that's all contingent upon, to a certain extent, you know, how fast the new pipeline situation negotiations go, how fast data centers and approvals. You know, I had some actually the one in Adams County that we got sued on was a third-party data center. They are completely unwilling to do anything in Adams County right now until the you know, the rules are clarified. You know, so
okay.
I just don't know. I don't know how long things are going to take to evolve to come up with the solutions out here.
Okay, so of these 47 wells that we're discussing, how many currently have CDPHE, I guess, permits for combusting?
JB's probably in a better scenario to discuss that than I am, but I know we've filed well over half, or at least more than half. I don't know how many we've actually secured final approval on. That process has been a 6 to 12 month process. And like I said, they've kind of been jumping around as to whether we even need them on some of the leases or not, because the volumes are so small. So it's, you know, some of them we've been filing, and it's not a free process either. It's a lot of money and consultants' time and things of that nature just to get a permit in the queue.
Yeah, I understand that, but in the director's recommendation, I think staff is under the impression that you have CDPHE permits for all of these wells. At least that's the impression that I get from the director's recommendation. So I'm trying to figure out if you do have permits for everything that needs to be permitted.
And Mr. Ingve,
No.
you can certainly continue to try to answer that question. It appears you do not have the answer. It also appears that your colleague, Mr. Condell, has unmuted. Do you want to allow him to take a shot there?
Yeah, he's been doing the permitting. I'll let him kind of speak toward where we're at on different permitting stages here.
We have 22 combustors that we're applying for. We have submitted permits for 11 of them. We have a handful more ready to go upon the conclusion of, or the outcome of this. We have 5 issued permits. We have 4 permits that are about to go to public comment. And we have 2 permits that are pending CDPHE action. I pulled some information this morning. We submitted the first 2 permits that were finally issued to us when we submitted the permit application. The application sat dormant at CDPHE for 9 months. And then it was a 3, 4, 5 month process before they went to public comment and then were issued.
Okay, thank you. So based on the numbers that you just shared with me, am I to understand that you either don't think you need a permit for all 47 wells, or are you going to apply for permits for all 47? I'm wondering if you could break that down for me, what that would look like.
We began permitting with the higher producing wells, the more MCFs, worked our way down. We believe 3, 4, 5 of the lowest producing may not need permits. But we also had to balance it with workload and the economics, as Mr. Ingby said, of just the cost of what permitting takes.
Thank you. So the wells that would not need a CDPHE permit, would you still anticipate putting combustors there? I don't know if combustor is the right word, flaring equipment.
Combustor is the correct word.
Okay,
Combustors are there, but we don't believe the emissions rise to the level of a permit. But things at CDPHE change on a daily and weekly and monthly basis. So pending the outcome of this, we will continue our analysis and submit permit applications for the continuing lower producing wells.
thank you. So what is the status right now of these 47 wells? Are they, I think you put in, but I can't remember, are they shut in right now? Are they producing? Sounds like some of them are producing. I think I'm a little confused as to, are they in purgatory? Like, what is happening with these 47 wells?
They are producing and combusting gas.
And combusting gas. So they're all combusting right now.
Yes.
So I don't know if you saw Adams County, again, their submittal, which is that they went out and looked at some of the sites in Adams County and did not see combusting equipment. Did you see that comment from them?
I did, and I'll turn that over to Mr. Ingby on the operations side.
Yeah, that was on a well that was down for a while. I think it got returned to production. I think we stole its combustor for another lease, and there again, it's a 1 MCF a day, maybe type of well. Not sure that even a permit is going to be required, but yes, that's one that we definitely need to get back a combustor to. But like I said, we're a little chicken and egg situation here. Without approval of the variance, putting combustion equipment does us, it's just another, waste of money and filing for permits and things. And then I'll tag that on with the financial assurance. I mean, there's still, I don't know, I don't have regulatory certainty, quite frankly, whether I'm going to be allowed to continue to produce. So we're kind of in a conundrum here as to, okay, do we think they're going to allow us? Now we've been working with staff and they've been great. I don't think we're hiding anything from them. I think they're kind of aware of the situation. And it's without a favorable outcome here or a favorable outcome on financial assurance, all I'd be doing is just burning good money and, for no reason, for buying equipment and filing permits that I'm not going to be able to use. So we're trying to do a balancing act as far as, how we get there. And we haven't dove in full fledged, but we haven't done nothing either. We're kind of in that middle ground.
Thank you. I guess I'm wondering, you talked a little bit about some additional pipeline that's being built, another existing pipeline system, but I think also owned by Anadarko. And I'm wondering if you could talk a little bit about any progress and discussions about connecting to either this new infrastructure that you've said is being built or the other system? I think you called it the Wattenberg, but I'm not sure.
Yes, and I don't know if we can put up the map. I think that might be better from an illustrative standpoint. I think we have to be, yeah, I think it was slide 5, right? There we go. It's a little difficult to see, but particularly in Adams County, in and around and east of the airport up there, if you can see the gray lines are what Anadarko refers to as the Wattenberg system. That was built almost at the same vintage and time frame as Third Creek, albeit it was a regulated entity. It came under FERC at the time, so it was built to different specifications. That system is still active. And you can see in particular, you know, say about where that radar station is and points even all the way out to the Calson station. There is an opportunity to try to move leases that are in very close proximity back over to the Wattenberg system. We have, like I said, been blue in the face trying to talk with talk to Anadarko to get wells hooked back up to that existing system that is active and operational, and generally have gotten almost zero response. Now, part of that I likely speculate is because we've got legal action against them. And now the legal action, we're getting into a different phase of that, and potentially there'll be a desire to try to settle, and maybe we can come to a conclusion about, you know, at least some of these leases moving and gravitating back over to the Wattenberg system. That would be fantastic. We would love that. We've been trying to do that and talk them to do that for 4 years. You know, when Third Creek first shut down and they said it was safety, 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 I said, well, some of these leases, we had some of these leases that were on the same sites that had a Wattenberg connection that wasn't active and moved over to Third Creek, and they wouldn't allow me to put it back on Wattenberg. So I contend that, you know, their representation that this was all safety had more to do with contractual situations than it did safety. Or else you'd think they would have cooperated to try to help assist producers in doing that.
Okay.
I say I could highlight some of the other stuff or discussions on that, but yeah, so a lot of that Bronco stuff, we had dialogue even just this week with the owners of Bronco, and we're trying to see if we can get, in particular, those 3 dots down there tied in relatively quickly to that Bronco system. Tenderfoot is another one. That's the pipeline name that GMT has built. Some of these they're waiting on Williams also. There's another problem affiliated with Williams, but I think in the next 6 to 12 months, the options, at least for that corner of Third Creek, might become a lot better. But as you can see, there's a lot of things out east to the southeast part of the map with a lot of dots that, even though they're not very, don't have hardly any gas affiliated with them, that aren't in a position that looks very ripe for trying to come up with a solution. So that might be an area where the crypto is a better situation. But there again, the counties and the positions that they've taken, in particular Adams County and Arapahoe County, is kind of said they're willing to ignore it. Adams County is not. You know, makes that difficult to justify spending money, and there again, I tag team on again. If I don't get the variance, and if I don't get a financial assurance situation that I'm comfortable with, you know, is there a reason right now as we sit to go spend more money?
Yep, I understand. So I have 2 more questions. I think just 2 more, I hope. If this commission was not inclined to give, you know, an open-ended variance, I have appreciated over time you sharing with the commission your efforts to figure out beneficial use for the natural gas from these sites. And I like that you're continuing to talk about these options and working through some of these issues and some of these options. You know, what kind of a time frame do you think would be reasonable for the commission to consider?
Well, I'd probably take whatever you give me, but I would think, within, say, a couple years, a majority of these sites will either have on-site data center type operations, or be connected back to pipeline. And that there again is dependent or contingent on financial assurance, but you know, that's kind of where we're sitting today, I guess, would be my best guess.
Okay, thank you. And then I think what's going to be my last question, I'm trying to kind of understand the entire picture for your portfolio of infrastructure. What do you think is going to happen with the remaining wells that you aren't asking for a variance right now? And my understanding is they're shut in right now?
They're shut in, and they're
natural
again, you know, the same strategies that I'm discussing with regard to the one that we're applying for the variance can also apply for the shut-in wells. There's more gas there, so those have a little bit better economic traction if we can make something work. You know, the crypto data center concept, while not necessarily outstanding economics, I think I can make work. But we kind of need to see what posture Adams County is going to take. I just, you know, I think the first discussion study session they're talking is March 8th. You know, if that turns out to be an 18-month process before we get an idea there, you know, some of the shut-in wells would certainly could benefit from that. Like I said, one of the newer aspects that we're looking at is now that Anadarko has physically abandoned the Third Creek pipeline system, we've had it legally evaluated as to who owns abandoned pipeline, and whether there is an opportunity to potentially either use some of that abandoned pipeline, you know, in strategic places, or if nothing else, use it as conduit to where you could feed new pipeline through the old pipeline and do it in a very more economical way than what a full-scale build would look like. So we're seeing if there aren't strategic segments that possibly that could be pursued. I think there are. We are, in particular, they're going to, if MAP comes back on. In particular, Anadarko was a little bit more open to the high pressure pieces of pipe that are out there, the kind of the darker red, the more blood red stuff, and maybe allowing us to utilize some of that piping. I probably should make another statement here too. There is a new development. The pipeline system immediately to the north is a DCP pipeline. Also, it's an old Duke system. It's not on there. There's no infrastructure related on this particular map. But when Third Creek was first shut down, we approached them about trying to get at least portions of the northern sections there tied back into their system. They said their plant was full at Roggin, that they didn't have any interest in taking those quantities of gas at that time. That has changed. I've had discussions with them in the last 12 months, 6 to 12 months, and they are now open to taking gas to the north. So there's opportunities where there's some abandoned Third Creek pipe that some of these leases were tied onto that either directly cross DCP lines or are in very close proximity of DCP lines that might avail us to tying in some leases that way.
Okay, so you're still exploring, still some options out there is what I'm hearing.
There are some, yes.
Okay.
But in some of it seems like oftentimes winds down to cooperation level with Anadarko, and quite frankly, that hasn't happened. You know, we initially tried to get them in front of the commission and explain themselves, And that was rejected by them and not pursued. I still think there's an avenue for the commission to possibly pursue them under their current rules. Chairman Robbins kind of challenged me to concepts and ideas, and I've been working on a list, and I think I might do that in another public session, or I'd be more than willing to meet with commissioners on a working session or something like that as to where I think maybe the commission has a role here, without necessarily having to pass new legislation. I think the commission certainly has taken it upon themselves to regulate midstream companies. There's a bonding mechanism out there. They also are involved with any spills, and leakage is all directed through the commission, and they're utilizing their resources. I don't see why pipeline closure events shouldn't have to be directed through the Oil and Gas Commission. And I think as part of that pipeline closure, I think the questions could be asked is how many wells is this stranding? I mean, it's within you guys.
Okay, sorry, that's not something for us again to solve today. Let's just stick with the
Okay.
variance request if
Sorry
you
about
don't mind.
that.
Otherwise, we're
Rabbit
gonna head down so many rabbit holes. Thank you so much for answering my questions.
No problem.
Mr. Ingve, I want to follow up on some of those questions. So you have 47 wells you're seeking a variance for. Your colleague, Mr. Condell, indicated that you've received 5 CDPHE permits of those 47, and that perhaps 3 to 5 don't need a permit because of the level of gas. That would leave, and that you've applied for, so 5 have received, you've applied for 11 total. I don't know if 5 is of the 11, but just being generous, there's.
Clarify real quick, it's 22 locations. The combustors are permitted on a location basis, not on a well basis. And actually, I know a couple of the permits that we've actually secured right now are on multiple well leases. I think there's one that's a 7-well lease and one that's a 6-well lease. And I'd have to sit there and think about it a little harder as to how many of the wells of the 47 are actually covered by the approved permit. I see Mr. Condell kind of actively trying to come up with that number, but because the locations have multiple wells behind them, and I do know those were the ones that generally had a little larger volumes, and those are the ones that we concentrated on first.
All right, Mr. Condell, maybe you can answer the question. The question is, the relief you're requesting is there's a condition precedent that you need to have the CDPHE permit in hand. And I'm trying to get an understanding of how many permits you have in hand, how many you've applied for, and how many you've not applied for which you're seeking a variance. Can you answer that question?
We have 22 combustors in this application. We have applied for 11 CDPHE permits. We have not applied for 11 CDPHE permits.
And you've received how many permits?
We've received 5. 4 have been processed and are about to go to public comment. 2 are in CDPHE's hands for further processing.
Okay, now a second question. As of 1/15/21, routine venting and flaring was prohibited. I realize you would like to create a legal argument that we don't have that authority. I believe we do have that authority. We put it in our rules. We reiterated it in a form of proceeding. So the legal argument aside, you were supposed to be in compliance with no routine venting and flaring as of 1/15/21. For operators whose gas lines after and then we even gave you an operators in your instance, a 1-year grace period. So as of we in the rule, we said we would not take action, and that as of 1/15/22, you would needed to have filed a gas capture plan to establish how it is you're going to comply with the rule. Have you filed a gas capture plan with the commission?
Yes,
Part of the variance.
as well as the variance application.
Okay, I'm gonna ask staff that same question. So I want to make sure that it's accurate that you filed two things, a variance plan as well as a standalone gas capture plan. Is that accurate? Is that your testimony?
Gas capture plans were attached to Form 4s.
Okay, great.
And I might comment a little bit or augment that if that's possible here.
No, actually, go ahead.
Around that January 15th date, we were working with staff. Their staff had made a recommendation or had put a couple things out saying that there was discussion amongst them to see if they were going to handle Third Creek differently and what kind of point forward looking they wanted us to do. And the suggestion at that point in time was to file Form 4s. This would have been in fourth quarter of 2021, prior to the January 15th date that came. And we were kind of waiting for staff to see whether that was going to do it or not. And I think we got noticed on January 23rd from staff saying that wasn't going to work, and that a full-scale variance was going to need to be applied for. And I believe our variance we applied for over a year ago now, by mid-February. It took us a couple, 3 weeks to put that together and get it filed. So we thought we had it covered, and as it turned out, that was not going to work. So we had to go this other route.
Okay, follow-up question to the CDPHE applications. You've got 11 that you've not applied for. You've been in this predicament for at least a year, if not more, knowing that you needed to get CDPHE permits to allow this commission to consider a variance. What is the rationale? Why haven't you applied for the CDPHE permits?
Let me answer. Like I said, it was largely, we didn't know when this hearing was going to take place.
No.
Kind of been doing them two at a time.
That's not an answer, Mr. Ingby. I'm sorry. But if you need
Okay.
to have a CDPHE permit in place to give the commission authority to consider a variance, why was the CDPHE permit not even applied for ahead of this hearing?
It wasn't done. Like I said, it was largely due to economics. If this wasn't going to succeed, there was no reason for spending the tens of thousands of dollars in the permitting process. And CDPHE's process has not been very clean either. It's been awfully clunky. They've changed their rules on numerous occasions here. So I don't know. That's the best answer, at least at this point in time. I can
Okay,
give you.
no, that's fair, and I understand that it costs money.
Mr. Chair, may I make a brief comment on that
Sure,
issue?
Mr. Campbell, go ahead.
Thank you. This scenario is exactly why we have a variance process. I mean, regardless of the time put into rulemaking, good intentions, the merits of the rules, it's difficult to identify how or whether they're going to work in the real world. And there's always unintended consequences. And, Renegade finds itself between a regulatory rock and a real world hard place here. It is struggling to maintain its existence. And, it's not all altruistic when we say we want to keep the wells out of the orphan well program. But that is something that is in the mutual interest of the state and Renegade and consumers. It allows them to continue to operate them. And as Mr. Ingby noted earlier, plug and abandon them where there are some that need to be plugged and abandoned when they might otherwise sit out there for a decade or longer, just based on the current orphan well progress. So, I mean, we would ask that you keep in mind that there is an issue here, a chicken and egg issue. These combustors, as I understand it, run upwards of $150,000 a pop.
Yeah, not that expensive, but they're not cheap either.
Well, they're,
The whole
so the whole process and for Renegade to invest that money only to find out that it was never an option to begin with, is a big lift for a small company like this that's really, struggling and trying to do the right thing and being transparent. Production's reported every month. Staff hasn't taken any action. We think that there has been and continues to be some sensitivity to the unique circumstances that Renegade finds itself in, given the Third Creek shutdown. And we would ask you to just keep in mind that the issue here is they can't fully comply with the rules. And they've come before you, looking for some relief and doing their best to work with this commission and staff to get to somewhere that works for everybody. So
And that,
I'll stop there.
all right, no, I appreciate that. And that actually suggests another question, in that you just indicated that your client cannot comply with the act, which means that with regard to the routine venting and flaring, they need to routine vent and flare in order to produce the oil. So that gets back to the variance request in the 5 criteria. And the first is a good faith effort to comply with the act. And Renegade has been aware of the rule since January 15th of 2021. We're now in February of 2023. Renegade was aware of the fact that it was that it had concerns from the shutdown of the Third Creek in 2018, 2019. So help me understand the quote good faith efforts to comply with the act that Renegade has partaken either since January of 2021 or even since the Third Creek shutdown, because I'm having trouble with the concept of granting a variance for another year, another however long, given that I've not seen, at least from the testimony to date, I've not seen a lot of good faith effort to comply. I've seen a lot of efforts, but there's been no relief. There's been no, not much, if anything. So anyway, I don't want to testify for you. You let me know your understanding of the good faith efforts since January of 2021.
Well, I'll defer on the factual questions, of course, to my client, but Mr. Chair, the application was filed in, as Mr. Ingby noted, February of 2021, and we don't control the docket. It's not our fault that we're here in 2023. It would have been helpful to get some relief on that much sooner, and the commission's docket just didn't permit for that.
No, actually, that's not the question. And I realize everything's bogged down and it takes to get onto our, but just because it takes a while to get onto our calendar, that doesn't preclude good faith efforts. So I'm actually asking Mr. Ingvey for factually, what are the good faith efforts? I mean, enumerate them for me since January 15th of 2021.
Well, I would certainly say that mortgaging my house and dipping into my retirement account would qualify to some of that. Like I said, there's not a significant Third Creek operator out there that hasn't walked away. I'm still trying to make a run at it. And I needed a little bit of grace with regard to this issue on the venting and flaring. I know it came up in rulemaking on numerous times. In fact, I think it was even your suggestion when you were talking about an orphaned well amnesty program. And that was intriguing, but it was rejected. If there were clearly wells that were going to be more difficult to get there, then that could have been a tool utilized.
Staff recommendation.
The staff had been working with me on this and trying to get where we thought we needed to be here today. We're producing a very, limited amount of my portfolio to basically generate at least some cash flow so that we could see whether, depending on whether it's financial assurance, or whether it was this venting and flaring application, whether it was this new pipelines, and whether these, I've had so many discussions with so many people, and it looked as if things were coming together, but then they don't. And a lot of that, I think, you throw COVID in there, you throw the rulemaking, it's especially for small operators and even large operators for that matter. There was a state of paralysis over this industry for about 18 months trying to figure out where we go. There was no regulatory certainty on anything out there as to whether we were going to be successful. You don't know what kind of stress and strain this has put on me personally, and my marriage and all this kind of stuff. I'd say my wife is another one who is advanced. Why don't we just walk away? This is ridiculous. Why are we chasing good money with good money with bad stuff? So I guess I take a little bit of objection to the characterizations that I haven't made incredibly good faith efforts here to bring this and to get to this point in front of you today.
I'm not suggesting you haven't. I just wanted you to articulate what they were. So thank you for that answer.
And Mr. Chair.
Mr. Campbell, I see you've raised your hand. Go ahead.
Thank you, sir. We would also remind the commissioners that you have a director's recommendation of approval. And if anybody's plugged into the issues here, it's staff. As Mr. Ingves testified, he has kept them in the loop and he has worked closely with them over the years, trying to find solutions here. And staff is well aware of the elements that we need to prove in order to be granted a variance, and understanding those elements. The director has recommended approval, and we would respectfully submit that, although we understand and acknowledge the buck stops with the commissioners, you have a staff for a reason, and their recommendation of approval, we think, should be given serious weight and honestly a certain amount of deference. It's difficult to convey in a 30-minute hearing all of the effort and work and hundreds of hours that Renegade has put in trying to get to a solution. They've attached as an appendix representative letters that they've sent to Anadarko. I think is Bronco in there as well, Mr. Condell? Just Anadarko, but representing attempt after attempt after attempt to try and get to a solution. Of course, you're all well aware of the Bitcoin mining dust up, which resulted in litigation, which we arranged for the dismissal of up in Adams County. He's looking for solutions. And when you weigh these circumstances against the very low volumes that we're talking about here, we think that we're actually leading to waste if they're unable to produce these wells, and there's no meaningful public health, safety, or welfare, environmental or wildlife impact. If he put generators out there, compressors, they would combust the gas, to move the gas into a pipeline no differently than the combustor does. And I believe the combustor even has a better destruction efficiency. We end up in the same place. So thank you for that, for the opportunity to say more on that issue. We think they have demonstrated good faith.
Thank you, Mr. Campbell. I am done with the initial line of questions. Commissioners, I'm happy to call upon one of you for further questions. I do note that our staff, Diana Byrne, had visualized herself at some point. We probably want to hear from her. I don't know if we want to call upon her now or if commissioners have further questions before we allow her to provide some perspective. Commissioner Messner.
Thank you, Mr. Chair. And I certainly do want to hear from staff. And so I did want to have an opportunity to just ask one or two questions to the applicant prior to staff sharing some thoughts. Mr. Ingve, just so I understand, how many of these sites currently have combustors on them at that are at the efficiency that you're indicating in your application of 98%?
I think to my best knowledge, it's 20 right now. We've got one that's in the application that we're not producing. Or we got 2 locations. JB's telling me that we're actually got applications in that aren't on production right now. Everything else has a combustion device on it. At the 98% efficiency. And I should also make note, I failed to make note during the presentation too. One of the sites that we have out there, I do have a crypto operation by a third party that is being initiated there also. So that one may or may not be necessary here in the near future.
Okay, and then my second question is, are all of the wells that are being proposed in this variance in compliance with COGCC rules today?
The best of my knowledge, yes. Let me,
And that
I
includes.
mean,
all
there might be an
required
inspection
MIT
item here or
tests.
there that, you know, something minor housekeeping wise that, no, I think these are all actively produced, so MITs aren't a problem. No, I think I can say, yeah, I think everyone here is in compliance.
Okay, that's my questions for right now, Mr. Chair. Would love to hear from staff.
All right, further questions from commissioners before we ask staff to provide some perspective? Commissioner Cross?
I do have questions, but I'd like to hear staff's perspective first.
Okay, Commissioner Ackerman, you've not said anything. Are you shaking your head? Are you good to go to staff first?
Yeah, I'd rather hear from staff first as well, Mr. Chair. Thank you.
Okay, Ms. Byrne, you are recognized. Generally speaking, I think you've listened into the question and answers over the course of the last few minutes. You know, I don't need to ask you a specific question, but can you sort of weigh in on this dialogue, on the variance request, on the director's recommendation, on the perspective of good faith efforts, and on the perspective of gas capture plan filings, et cetera? Those are sort of some of the questions that I know that are out there.
All right. So when these wells went with Third Creek in May of 2018, there was a very deliberate parsing out of the ones that would be considered gas wells in the terms of GOR, or that their value in production was in the gas. So the wells that are currently being contemplated with this variance are wells that had low GOR, and that there was a value in the liquids being produced that superseded the value of the gas, and the ability to obtain those permissions from CDPHE was there with the quantities that were expected to be combusted. We right along have required that the gas is combusted with a 98% effective combustion device, which was greater than the requirements at that time for CDPHE, because their requirements were a 95% effective device. That is our expectation, that those wells that are producing in this manner, that their gas is controlled with a 98% effective combustor. And the data that was submitted for the variance, and this is a variance, not a gas capture plan. The gas capture plan is one where something else is being done with the gas on site. So the one that was just mentioned with the crypto would end up needing a gas capture plan, or it could be covered under the variance, right? The gas that's available that would traditionally be sold is not being sold. So we're looking at that aspect of the well's production. And either it's going directly to a combustor and doing so under an approved variance, or it's effectively doing the same combustion, but benefiting somehow with the crypto. we have also right along with any variance that we granted even prior to the rule change, that we required that CDPHE permits were applied for and received if needed. And I think that that's one of the things, and CDPHE world is not at all my forte, but there are levels of emissions that trigger. There's like a letter acknowledging, yes, you applied, and then there's another one that's permit, and there's heirs ID or whatever. I do think that and I think all of these are going to have already been in the non-attainment area, so those thresholds were the same across this time frame. They didn't change with their rulemaking a year ago, 2 years ago now, where the non-attainment area went all the way to the Colorado state line. So this, in staff's opinion, it was an appropriate variance application. The wells that were chosen to be utilized in this manner were low GOR. They were, again, the ones that were high GOR are shut in and remain shut in. Does that touch on all the questions?
Was a gas capture plan applied for?
So when
Were
the
these
rules changed,
22 locations?
when the rules changed, these all needed to be a variance because there's not a beneficial reuse of the gas on site. Rather, it's being combusted rather than sold. The gas capture plans were for those wells that chose to utilize it differently. Instead of combusting without benefit, they get a variance. The gas capture plans are speaking to those that are utilizing it to generate electricity on site, either for the production of the oil and gas, or we've also allowed for in the data server world, or they're heating their tanks, or some other yet to be offered up use of that gas on site. These are not utilizing the gas. It is being combusted as a waste product. So not a gas capture plan, a variance.
Okay, so that part of the rule from your perspective was complied with in terms of the appropriate procedural route.
Yes, yes, they applied, and they applied pretty early, and we didn't quite have everything aligned for that process.
Okay, you testified that the appropriate or the required CDPHE permits needed to be applied for and received.
Well, so we also recognized, and so our COAs leading up even pre 181 were always like, we expect you to go through that process. And the delays have been different across my tenure at this COGCC in terms of what it takes to get that permit. So we expected that an operator evaluated the thresholds. They have that data when they have their oil and gas production numbers, and it may be aggregated at a singular battery. So they have those numbers and take the appropriate steps for that CDPHE, for those CDPHE requirements. So we don't necessarily backtrack, and I can tell you that previously we had a link that we could more easily check, but that got broken with some database changes a while back. But we do expect that it's applied for, and we kind of draw the line there, because then the process should work its way through. And if a permit is required, then CDPHE's process will issue that permit. And again, some of these may not hit the threshold, the tonnage threshold that requires a full-blown permit, but I don't know that for sure. The operator, it's incumbent upon the operator to evaluate that and go through that process.
Right. No, I appreciate that. And we heard from the operator that a few of them did not require a permit, but that 22 did, and 11 have been applied for, and 11 have not been applied for, if my notes are correct. Commissioner Messer, you'd raised your hand earlier. Did you have a question?
Thank you, Mr. Chair. Yeah, just I guess a clarification as far as how, Ms. Burns, you're interpreting the rule, because I'm looking at Rule 903, and it talks about in paragraph 3, at wells that have commenced production operations prior to January 15, 2021, and that are venting and flaring natural gas because they are not connected to a natural gas gathering line or putting the natural gas to beneficial use, the operator may request permission from the director to flare or vent by submitting a gas capture plan via Form 4 no later than the date of the operator's previously approved Form 4 expires, and in no case later than January 15th, 2022. It then goes on to talk about if they lose access after the gathering line or of the gathering line after January 15th. But I guess, so the question is, I mean, I understand that after January 15th, 2022, the applicant would need to be working under a variance, but in the time between January 15th, 2021 and January 15th, 2022, this operator should be working under an approved gas capture plan that in turn, they should still be working under while this variance is being processed. Is that how, that's how I'm reading it? Are you reading it the same way?
So I guess it's the way it's characterized there. So what we did is that the allowance was that it can be done at staff approval until January 15th in 2022. And at that point, it had to be an approved variance or an approved gas capture plan. So those applications that were done in that time frame and later 2020 and beginning of 2021, we're still done at staff level with the COA saying that this well needs to have an approved gas capture plan or a variance by January 15th of 2022. So I guess, I don't know if it's semantics, the way we administered it or whatever, but we continued with the sundry process, acknowledging those wells that were in that situation at the implementation of the new rules, and to get them, and that was, I think that was the intention of the allowance for the 1 year, that to get everybody that time to get those things in place. So could call it a gas capture plan with those last sundries that were approved, but we weren't considering them gas capture plans. For us, the gas capture plans were singularly those wells that could demonstrate that they were beneficially reusing all produced gas on site with no need to flare excess gas or combust excess gas. So, okay, maybe those were gas capture plans that were approved via sundry, but as we implemented the new expectations, it's a gas capture plan is utilizing all without combustion, excess combustion, because realistically all the stuff utilized in the gas capture plant is also being combusted on site. And those that didn't have enough of a quantity, then those are variances. It's clear as mud, sorry.
Okay, and so I guess my, I mean, I do read it a little bit differently, but it is what it is at this point. I guess my question is, under what plan is this operator operating under at this point? So understanding that we're in a variance proceeding right now, over the last year, they've been operating under some plan that requires some standards and some oversight. And so that's what I don't understand at this point, is what they're operating on under at this point. As it's clear, they don't have permits in hand from CDPHE, and they are currently venting or flaring. Well, it sounds like they're venting at some of them because they don't have combustion devices at all of their locations.
Yeah, that I don't have that confirmation. They applied for the variance, so I guess that's where we would have landed, that they are abiding the requirement in 903 because they can't do it with a gas capture plan. And in order for them to continue, they have to have the variance for those wells that cannot beneficially reuse all the gas on site.
Okay, thanks. Ms. Burns, just one other question, and I'll acknowledge now that I don't, you may very well not know this answer, but to the best of staff's knowledge, are the wells that are being applied for in this variance proceeding in compliance with COGCC rules to this date, including any necessary Bradenhead testing or MIT testing?
So the ones that are being applied for are active wells. So the only requirement for them would be Bradenhead testing, and Renegade is up to date as far as I know with, well, I do know because I just did the stuff. They did do the required Bradenhead tests. These are active wells, so there's not mechanical integrity tests that are associated with that. As far as I know, the reporting is up to date. I haven't seen anything lately that would give me pause that way. Yes, absent our staff going out in the field, I have to assume that the rest of the requirements are being abided.
Okay, thank you, Ms. Burns.
Commissioner Cross?
Thank you, Mr. Chair. And I'll say that I think a few of my questions have been answered. So I'll start off with just a couple clarifications based on some prior questions. First, Commissioner Messner asked about the number of ECDs that you have on site. Was I correct that you have 20 ECDs on these sites currently?
That's for Renegade, correct?
Correct.
Yes, we applied for 22 combustors. 2 sites do not have a combustor currently, so there are 20.
So that's the 22 combustors are for the 11 permits that have been filed.
22 combustors either require or may require permits. We have filed for 11 for the higher producing combustors that combust more gas and have higher emissions.
Okay, so the 22 is for the 22 sites
Yes,
that you're talking about, the location. So it's not that you have 20 of the 22 now and you're going to need to get additional ECDs for the 11. Just the 2 additional ECDs are what you're going to need.
correct.
Okay. And you said that the ECDs are approximately $150,000 each.
No, that was incorrect. An ECD, an installation of an ECD for our wells, appropriately sized, installation, permitting, consultants, CDPHE fee are $30,000, $40,000, $50,000 all in.
And of that, how much is the application and the consultant fees separate from the actual equipment?
Probably half and half.
Okay. And there's a couple questions going back about the fact that there's been 11 that have had permits applied for that will apply to locations, some of which are multi-well, including a 7-well and a 6-well location. Approximately how many wells are currently covered of the 47 by the 11 permits that have been filed?
I can count. Approximately 27 of the 47 are covered by the permits. 27 wells of the 47 wells.
Okay, and
I'd like to, okay, go ahead.
And you also mentioned that there was a handful waiting to be filed with respect to the permits. Approximately how many is the handful? Is it all 11 or is it?
It is, but it is. All 11 may need permits. Ms. Byrne made a good point that slipped my mind. Of the ones that are not filed, 8 of the 11 are in Elbert County, which is an attainment area, which has higher thresholds of emissions before you need to file. And they are some of our lower combusting wells, combusting the least amount. We have not done that analysis as to whether they need to be filed or not, but as we stated, the permits that have been filed for are the higher emitting wells. The ones we have not filed yet are lower emitting wells, lower emitting combustors. And most of those are in Elbert County, which is an attainment area, not a non-attainment area.
And I know that you went through several different, and this may be more for Mr. Ingve as opposed to you, Mr. Condell, but you went through several of the facts about different steps that have been taken, solutions trying to be garnered with respect to the situation. And I don't want to hear regulatory issues. I don't want to hear Anadarko issues. I want to hear specifically some of the things you're looking at. You've talked about some ideas with looking at cryptocurrency mining. I'll be honest, I think one of the things is that the situation isn't completely unique. It's the way it's developed is somewhat unique. But if you look in North Park, there's some other operators there that are also quite far away from any takeaways for gas, and they're looking at other options, including hydroponic greenhouses. They're looking at trying to do liquefaction. Have you talked to any other operators about steps that they're trying to take as alternatives to combusting?
Well, I'll let Mr. Ingve jump in, but I'd like to try to articulate and make the point again. How diverse geographically these wells are and how little amount of gas is available. North Park has got a bunch of gas and it's near each other and they can pipe it all to a central location. We have very little gas and it is diverse and it cannot be piped and made into a central location. It just simply cannot. And then I'll let Mr. Ingve continue.
Yeah, he kind of hit the highlights. The amount of gas that you're talking about on those type of installations is orders of magnitude larger than the type that we have from an average location here. It wouldn't support the type of activities that they're doing. I mean, even though it's still not a lot of gas, it's a lot more than what we have. And they're new wells.
Okay, I think that's my only questions for right now, Mr. Chair. I think I'll have comments during deliberations, but that's the only questions I have.
Commissioner McGowan.
Thank you, Mr. Chair, and this is for staff, I think, this is for Ms. Burns. If she's still with us.
There she is.
Thank you. Ms. Burns, could you walk me through staff's thoughts about, if I'm understanding correctly, these 47 wells, in staff's opinion, are producing such low levels of natural gas that staff does not consider it wasteful for it to be combusted instead of finding a beneficial use or other saleable option? Is that why staff is supporting the variance request?
Yeah. Again, there are more than 47 wells on Third Creek, and the ones that were asked for, even from the beginning of Third Creek going away, were only those with what would be deemed a low GOR. And of that, in our world, a gas well is a GOR of 15,000 or greater. These, I didn't pull up the thing, I want to say ranged up to about 2,700. So fairly low GOR. And those emissions were controlled, that it's expected that the gas that was not being sold any longer would be combusted rather than vented. And so they're looked at both the value of gas dollar-wise and also the energy value. And these met that criteria. So in terms of waste, it was minimized. and did allow for production of those wells and a benefit to the mineral owners.
Okay. But it's not such a small amount that before the Third Creek incident, it was considered a saleable amount because they were connected to a midstream operator, correct?
Right, but then when you start to look at what it costs to acquire right-of-ways and run the flow lines and the gathering systems, that is very expensive. So those low quantities don't, I mean, probably aggregating all 47 wells would be hard to come up with enough to justify. I'd have to look, but a couple miles of new flow lines. So that trying to reutilize those systems that are in place is a more cost-effective method if that's available. So far, that hasn't been available. But these wells were given permission to continue to produce after Third Creek because their value was dominated by liquids and not gas.
Okay, but I feel like we have other operators who are in similar situations where they produce more of one than another, but we still require.
But they have
gathering.
access.
Say again?
But they have access. Yeah, we would expect absolutely that if this system was up and running, and even if it was an issue of buck and line pressure, that, okay, that's fine, but you're going to need to put a compressor out there. But that option isn't even there to sort of aggregate the gas and pump it up so that it can get into that sales system. That it's just not there in this instance. But yes, you're correct that we've got other ones with similar gas oil ratios that have access to a system that will accommodate that gas. And we expect it sold rather than combusted, and even preferentially not crypto or something like that.
Thank you.
Commissioner Ackerman?
Thank you, Mr. Chair. I appreciate it. Appreciate the testimony today. The great majority of my questions and more have been asked and answered already, but I do have just one comment and one question for the operator before deliberations. I had a difficult time with the characterization in the presentation of you're just asking for status quo here, no change. I mean, I think I would restate that as really this is a request to grant a variance to a practice that's really currently operating outside of standards or, at best in a gray area. And so, given that characterization and wanting to see how things go first, I feel like maybe another clarification is in order. The wells that are being requested here for a variance, as has been explained, are of the lower GOR varieties, but you do have some other wells that are currently shut in, as I understand it, that are higher GOR that are currently not the subject of this request for variance. And given the characterization that I mentioned earlier, and if you are successful in obtaining some sort of variance for these lower GOR wells, I wanted to verify that your intent isn't scalable in process. In that, I mean, you don't intend to then reevaluate the higher GOR wells and come back for another variance saying, well, you've stated, you've approved a variance of this sort in the lower GOR wells. This is just a little bit more of a step up. So I wanted to verify that it's not your intent to come back in for the higher GOR wells if you are successful in this process.
Someone from the applicant?
Yes, at this point, that's correct. Have we looked at other wells? It seems like we do have some lower GOR wells, but they're located on leases that produced overall a higher GOR. At this point, we're not considering any of those. Those are leases also that we hope that we get Wattenberg and Anadarko cooperation on that we haven't. So I don't anticipate it. And if you want to put handcuffs that I'm not bringing another variance for other locations to the commission for a while or something like that, I'd be amenable to that also. But at this point in time, I do not anticipate additional wells showing up on your docket anytime soon.
Thank you, Mr. Ingve. I appreciate that. I heard a soft no rather than a hard no there. And so I think I understand your testimony. Mr. Chair, that's all I've got for now. Thanks.
Okay. Any further questions at this point, commissioners? Commissioner McGowan.
Thank you, Mr. Chair. And I thought I had kind of figured out some questions I had about our rules and things to consider. But I'm wondering if AAG Davenport would be available to walk us through how we define waste and whether or not cost is supposed to be a consideration as part of looking at that definition. Like the cost to connect to infrastructure, which I feel like our staff is maybe utilizing as part of their consideration when they're determining whether or not there's waste.
Okay, appreciate the question. Oh, there he is, AG Davenport.
Thank you, Chair. I'm wondering if perhaps it makes sense to get through the rest of the questions for the parties and staff and then see if we need an executive session or a break before making a decision.
Okay, I appreciate that. Are there any further questions? So Commissioner McGowan, good question. We're going to table it just for a sec. Any further questions for the applicant? I am contemplating taking a break next because we've been at it for an hour and 47 minutes. Okay, seeing no further questions, let's take a break. It's 10:48. Let's just return at, say, 11 o'clock. And we will undertake deliberations and or questions for council at that point in time. Before we break, though, I do want to correct the record. I just want everyone to be aware that staff's witness, Diana Byrne, is indeed Diana Byrne and not Diana Burns. And I think some of us get that incorrect sometimes, and that's not fair. And she is our engineering manager. And so just wanted to correct that for the record before we went to our break. So with that, we will return at 11 and we will take this matter up at that point in time.
You're muted, Mr. Chair.
Thank you. New microphone, different way to unmute, still training this person from the computer. We are back. This is Colorado Oil and Gas Commission, and we are, I think, in the final steps of questions on this applications. Or we may be at the point for deliberation. Does anyone have any final questions for the applicant or staff? Okay, seeing none, I would recognize, if he's with us, Mr. Campbell, would you like to take any opportunity to sort of, you heard from commissioners. This is a little bit different than a court of law, but I do like to provide procedural process, and perhaps you'd like to have some, opportunity for response or to sort of close out your client's position after those questions.
I would, Mr. Chair, thank you. And I think I can be brief. So I think all we'd like to do here is address your question, Commissioner McGowan, about the relevance of cost to the concept of whether or not there has been waste. And, first and foremost, I would point out that I think since inception of this commission and the early beginnings of this industry, it's always been the case that the availability of a gathering system is relevant to how and when an operator, produces the gas for sale or instead flares and vents or combusts. And it has been the practice for coming on 80 years now that in circumstances where you have that very low GOR and no available gathering system, that provided the dollars make sense, both from an economic perspective and a regulatory perspective. It's always been understood that producing that well and venting and flaring that gas is preventing waste. It's creating value today as opposed to leaving it in the ground. It's taking into account, present value of dollars. And it's also rewarding operators for going out there and drilling wells, which are often in remote locations, and wouldn't do that if they couldn't get a return on their investment. You need a tipping point of production before you can incentivize a midstream operator to build the infrastructure necessary to go out there and capture this gas. And of course, early on, there wasn't a gas market at all. That's relatively speaking, more recent development, in our collective energy portfolio. So, it used to be a more oil dependent economy. But I from a legal perspective, I mean, we do have the definition of waste is contained in the Act. And it says at 3460-103-11 that waste as applied to gas, specific to gas, includes the escape, blowing, or releasing directly or indirectly into the open air of gas from wells productive of gas only, or gas in an excessive or unreasonable amount from wells producing oil or both oil and gas. Now, the Colorado Supreme Court, and that provision is still part of the Act, it hasn't been modified. And the Colorado Supreme Court had occasion to take up that language in 1955. And that was in the Union Pacific Railroad Company case, UPRC versus the Oil and Gas Conservation Commission of Colorado. And if you look at the facts of that case, that involved the Rangeley field out in Rangeley, the oil field, where the commission issued an order which, among other things, prevented the operator from venting, flaring, or combusting in lieu of putting the gas into a local or municipal system, for use at the burner tip. And the Colorado Supreme Court said, look, that's not what the Act provides for. The Act is very clear in its limitation when it comes to gas on when you can combust, flare, or vent, and otherwise sell the oil, when it says that the flaring, venting, or combusting needs to be excessive or unreasonable. So, it's our view that there is no such animal under the Act as a per se waste, merely by virtue of the fact that an operator believes it is necessary to flare or combust or vent casing head gas. And we would submit to you that case, which is still good law, and just industry practice, demonstrates that cost in this circumstance, given these facts, is in fact appropriate when you are evaluating whether or not there's going to be waste. So with that, Mr. Chair, unless somebody has some questions for me on that topic or others, gentlemen, I think we're prepared to rest and wait on the commission's deliberations.
Okay, thank you, Mr. Campbell. Appreciate the final response remarks from you, and appreciate you and your client's presentation to commission. With that, we will turn to deliberations. We'd probably seek to just visualize the 5 commissioners during deliberations, and we can get started at this point in time. I've got kind of notes all over the place, but I'm happy to provide some perspective to commissioners about this. These are not going to be final thoughts. These are just going to be initial deliberative thoughts, and it might help others consider where they're at with regard to this matter. But as I look at it, our rule, which Commissioner Messner read into the rule, and that was the rule that I was acting upon as well, says that as of 1/15/21, there will be no routine venting or flaring. And if an operator that is not subject to gas gathering as of that time, by January 15th of 2022, they need to file a gas capture plan. That has not happened, as best I can tell. And even if it has happened, that gas capture plan hasn't come to the commission for approval, or it hasn't been approved by the director. Hearing from staff, I believe they indicated that the other alternative is to receive a variance for continued venting or flaring. Mr. Campbell, do you have your hand raised?
Inadvertently, Mr. Chair, I'm very sorry.
Okay, I'm just trying to be conscious of folks that are before us. So in order to obtain a variance, you need to meet the criteria for a variance, one of which is the good faith effort to comply. And I specifically asked the applicant what those good faith efforts were. And my notes reflect that he mortgaged his house, that he's trying to make a run at it without defining the run, and that he's had a number of different discussions. Those were literally the three answers that I wrote down from the good faith efforts to comply. That is, in my opinion, not satisfactory to good faith efforts to comply to receive a variance. And I would also note for the record that the applicant has been aware of the fact that the Third Creek gas gathering line has been shut in for much more than just January of 2021, but several years before. And I think he knows that. He's had discussions with the staff, et cetera, back, and so that in and of itself creates some concern for me as to whether the elements of a variance have been met. Another element is this in compliance with the intent of the act? And that bears an understanding of the intent of the act as interpreted by the commission. And the interpretation of the commission of the intent of the act is after January of 2021, there will be no routine venting or flaring unless you meet one of the 4 or 5 exceptions. And in my opinion, at this point, I'm not seeing that the intent of the act is being met. I understand and recognize that this is not due to, well, as to the undue hardship needs to be analyzed not just as a hardship to the applicant, but hardship as compared to others that are in similar situations. And in this instance, I find that the applicant, that others have either gone away or pursued different plans. As Commissioner Cross noted, there are other operators that are doing different things that did receive a variance. And I understand maybe that's not available to this applicant, but at the end of the day, the applicant, found himself in this perspective. We have our rules in place. I do not find a positive finding on any of those 3 criteria, the good faith effort, the undue hardship, or whether this is the intent of the act. And frankly, I don't have my notes in front of me for the other 2, but I'm happy to hear from others and we can all weigh in together deliberatively on where we believe we need to go with this. At the end of the day, I'm not influenced that granting a variance for additional time is going to generate additional positive, productive for this applicant and for these circumstances. And since I don't find that the variance criteria are met, I'm not inclined to grant a variance for additional time. Those are just initial thoughts and deliberations. I could be swayed otherwise, but I wanted to get that out there on the record. Other commissioners with deliberative thoughts? Commissioner McGowan?
Thank you, Mr. Chair. And I maybe have similar thoughts, but also maybe a little different. So I don't think that when we're talking about waste and the definition of waste, that the idea that it's too hard or too expensive is a consideration. We're supposed to, the commission was very clear during mission change about why we did not want to see venting or flaring and why it was wasteful to do so. And in some of these instances, we're talking about wells that are in the non-attainment area. So I think we need to be cognizant of what that means from a protective perspective as well. I do think that Mr. Ingve has been in front of us multiple times, sharing with us his attempts to try to figure out beneficial use for the product, which I am appreciative of, including the crypto, which has gone for at this first part, maybe a little sideways with Adams County, but I hear that there's going to be discussion about that. I hear that there's potential to maybe hook up to different pipeline now that Third Creek has gone away. I do think it's taken the operator a long time to finally maybe wake up and understand what these rules mean and how they're supposed to be applied. That being said, I think I might be more open to a set time frame for a variance for the operator to really figure this out. And if it can't work, then we all know that it can't work. I do think that a variance, an open-ended variance in perpetuity would be excessive and unreasonable for this product, the natural gas, to be continually combusted. And so I think that's where I'm heading, or what I'm thinking.
Appreciate that, and appreciate the comments concerning waste. I mean, I think that's kind of a two-way street too. We are first required to regulate in a manner that's protective, and in doing so, not generating gas or oil because it's not protective is not considered waste. So I sort of look at it from that angle as well. And given this commission's finding that after January of 2021, there should be no routine venting or flaring unless you can meet one of these exceptions, I think that plays into it. But I want to hear from my other commissioners. Commissioner Cross?
Thank you, Mr. Chair. And I want to thank everyone for their presentations today, including Ms. Byrne for providing staff's perspective on this, especially since she was kind of put on the spot with some of those questions. I'll be honest, I don't know that I've come up with a decision yet, but I will kind of run through what I'm thinking. I'll start off by saying this was a very frustrating presentation, at least for this commissioner, particularly because similar to other operators we've had before us, it seemed like nothing is their fault. And I understand that the situation presented was difficult, but to say, well, CDPHE takes a long time, and Anadarko wouldn't let us connect to their gas lines, and COVID is a problem, and the new regulations are a problem. I fully appreciate the difficulties faced by this operator, but I think those are problems faced throughout industry. And we're not seeing the same complaints from every operator. I recognize that some of the operators in this area have left, and that's not ideal. I hate to put things on the orphan well program and list, but it's extremely frustrating to find that everything is someone else's fault. I also was particularly frustrated by kind of the veiled takings threat that was mentioned during it, and the idea that maybe this is a regulatory taking. I don't think that anything that's been done either by CDPHE or the COGCC at all rises to a taking of assets here. And in fact, the fact that they are continuing to operate at this point in time signifies that this is not a taking. The fact that there is a variance request pending shows that this is not a taking. And so before I get in kind of the details of what I'm actually thinking with respect to this request, I just wanted to point out that particularly those two aspects were extremely frustrating to me. When it comes to the actual variance request, I do agree with Commissioner Robbins, Chair Robbins, that we didn't really see all the requirements met for seeking a variance, in particular, a good faith intent to comply with the rules. We are seeing that a lot of things are being done, ways around the rule, but nothing was being done. And in fact, continuing to operate while there is flaring going on, although in an ECD shows that they're not doing a good faith attempt to comply. Keeping the wells shut in while trying to work some of these things out would be a good faith intent to comply. But continuing to operate as is while exploring other options, to me, does not fit that. And so I'm stuck in this predicament of, I don't think that what's happening now meets what's required to get a variance request. That said, I also understand and appreciate the difficulties faced by not having a gathering system, and particularly staff's suggestion that if they can get the CDPHE permits, then 100% this is something that we could work with. And I also appreciate Commissioner McGowan's comments that, you know, if we do something for maybe a 2-year time period, as was expressed by the applicant here, that maybe that would be an appropriate amount of time to give them a chance to try and get this variance worked out, and get the necessary permits in, trying to figure out other things, whether it be the crypto mining in Adams County and elsewhere, or whether it's some kind of additional gas gathering system, either redone through the Third Creek system or through one of the other gas gathering systems that's being put into place. So that's kind of big picture where I'm sitting. I think the other thing that jumped out at me was there was the comments that there's no adverse impacts, and consistent with what Commissioner McGowan said too. You can say that the status quo is not adverse impacts, and yes, it's a small amount of gas, and yes, it's an enclosed combustion device that's getting 98% effective, but there's still that 98% effective, and so there still are adverse impacts. And so I don't want the applicant or other operators that may come before us to be thinking that such small amounts are not an adverse impact, because those are adverse impacts, and trying to describe it as not being adverse impacts to me is problematic as well. So I'm definitely curious as to what my other commissioners think as well, because the lawyer in me wants to say they didn't meet the standards, 100% can't give the variance. But that said, I do think that this is a situation in which maybe we can do something like Commissioner McGowan proposed, and giving them some time to work things out. But I would be interested in hearing what others have to think.
I did. Ackerman, then Messner. It was a short call, so go for it, Commissioner Ackerman.
Thanks so much. Just have some very brief deliberative comments, and wanted to start by saying that it is a compelling fact for me, the force majeure closing of the Third Creek gathering system. That's a very hard hit to this operator's business model, and wanted to make sure that I state that that's very clear to me. And I certainly have some that feeds into my way of thinking to some degree. I would recognize, as was pointed out by the chair, that there was a systematic grace period placed in order to do your best to deal with those types of situations after the regulation restricting venting and flaring was passed. And I do find compelling that there were some measures taken by this operator to attempt to find beneficial uses for this gas within the economic and technological capabilities that are available at the sites. I appreciate the looking into cryptocurrency, the on-site generation, and the other issues that were mentioned by the operator in their presentation. I do, however, I don't have a lot of exposure with this operator being a new commissioner. But to just be frank and honest, I think a cautious approach is best. I think that was illustrated by, you know, the unwillingness to say that, yeah, we have higher GOR wells. We're not going to say that we're not going to come back and incrementally ask for more. I think that's demonstrated by the willingness, excuse me, as has been mentioned by my other commissioners, to continue to vent and flare, and to treat that as, you know, just kind of run-of-the-mill operations. And then to couch that as a status quo request in this presentation, I found that to be, you know, disingenuous and not a very straightforward approach. And so I'm inclined to be cautious on the path forward. And the question to me becomes: is the continued one of factual nature? Is the continued combustion of these amounts of gas acceptable in order to continue to allow production from these wells? And from a bigger picture perspective, is it in the best interests of the people of the state, of the consumer, and others, not just solely in the best interest of this operator, although we do have to have the interests of operators in mind as well? And if that's the case, does it remain the best option, either in the short term or the long term, to combust that gas on site? And would that remove incentive to find or continue, because I want to give the operator credit, to continue to strive to find better solutions for the gas that is being produced at these wells? Those are the questions that still swirl around in my mind. And, you know, I have not made up a decision yet either. I am open to the possibility of a potential short-term variance, but with, you know, pretty significant stipulations and achievable goals to eventually remove venting and flaring as an option from these sites. And so I want to make sure that it would be my intent for there not to be long-term venting and flaring, and that any variance would be intended to simply provide additional time above and over what's already been allotted to continue to attempt to find other solutions. So, Mr. Chair, that's my thought process right now. I do proceed with a cautious eye.
Thank you, Commissioner Ackerman. Commissioner Messner.
Thank you, Mr. Chair. Always appreciate my fellow commissioners' thoughts and deliberative comments. You know, I do think that it was this commission's intent to phase out routine flaring and venting not connected to natural gas gathering systems. I think that was clear during the mission change rulemaking. It's clear within our rules. It's clear within the statement of basis and purpose. I also think that it's clear that that there was a exception or a window that was created, and during deliberations during the mission change rulemaking, that window was specifically called out for situations like Third Creek. And so routine venting and flaring was disallowed as of January 15th, 2021. That additional year was given to operators in exceptional situations like Third Creek to develop a plan, a gas capture plan, in order to be able to understand, evaluate, and address the need to be able to either capture gas and put it into a sale line, or put it to other beneficial use. That entire year was given with the understanding there was going to be situations like Third Creek, and we wanted to make sure that Third Creek operators had an opportunity to be able to try to address those situations. And so these things were contemplated and were incorporated into the mission change rules and are now part of our rules that we sit with today. Although now today is February 2023, and this operator has come in front of us with a variance proposal. And best that I can tell, this operator still does not have a clear plan as to how they're going to deal with the excess gas that's associated with these wells, don't have a clear path forward on how they're going to address this situation, and understanding that the Third Creek gathering system was tragically eliminated in 2018 That's 5 years ago that this operator had an opportunity to begin to develop a plan necessary in order to be able to not only bring these 47 wells online, but potentially bring all of their wells online with, a creative, unique, proactive way to address the natural gas that's associated, as it is this commission's regulatory requirement that no routine flaring and venting of natural gas occur after January 15, 2021, with the exception of Third Creek. And so I think what I was hoping to see today was a clear plan that was laid out by Renegade Operating on how they were going to address this and a time frame associated with it, as far as how they were going to work through the steps, a plan that could have been developed over the last 4 or 5 years, but at a minimum have been developed over the last 2 years. But I'm not seeing that plan being presented today. In addition, there's a known requirement to have APENs in hand in order to be able to move forward with this. And not only does the operator not have all of their APENs in hand before they come before this commission asking for a variance as part of a gas capture plan moving forward, but they have 5 out of a necessary 22 in hand at this point. And so that's a little frustrating for me to see, is that opportunity in order to be able to be prepared prior to this hearing with the necessary plan in place, with the necessary permits in place in order to be able to ask for a variance. If those things were actually in place, this could potentially be a very compelling variance hearing. But seeing that there is no plan and that there is no permits in hand, that there's not even the necessary combustors on sites currently necessary in order to move forward with the plan. I also, like Chairman Robbins, find that the good faith effort to comply was not met by this variance application. Now, having said all of that, I do think that there is opportunities for this operator, should they have done what they needed to do up to this point, to make a compelling argument for a variance. But this variance hearing was requested. The applicant made their case, and from this commissioner's perspective, the applicant did not meet the burden of proof necessary in order to be able to have a variance considered, even with conditions of approval by this commission. And so I wish it was different. I wish the applicant would have had a plan in hand. I wish they would have had their permits in hand. I wish they would have had the equipment necessary in order to be able to move forward with this variance, but that is not the case here today. And so from this commissioner's standpoint, I'm not able to approve this variance.
Thank you, Commissioner Messner. In response to these deliberative thoughts, I did go back and look up the other 2 elements that I did not speak to in my opening deliberations. And one is no net adverse impacts to public health, safety, welfare, the environment, and wildlife resources. And the other is the potential for reasonable conditions to avoid, minimize, and mitigate. And I would echo the points you made, Commissioner Messner, in that, the fact that of the APENs that are necessary, 11 haven't even been applied for, creates a lot of difficulty for me. I still am of the opinion that the applicant has not met its burden based upon my initial deliberative comments. I understand from some commissioners that there might be a sense of giving a little time for sort of proving up, and I don't know that that's necessary because the proof needs to be here today. But if we were to go down that path, I think that granting a variance, but requiring as conditions of approval to avoid, minimize, and mitigate that the APEN applications need to be applied for. I don't know we can make them have a time frame for receipt because of the backup at CDPHE, but I mean minimally just applied for. And getting those combustors on site, as you indicate, Commissioner Messner, and there may be other things that we could contemplate, but I just throw that out there for the commissioners who are thinking that we may want to do something other than just take the measure up on its merits today, which is what what we really are supposed to do. And I would be in line with you, Commissioner Messner, that the applicant has not met his burden of proof. Mr. Cross.
Thank you, Mr. Chair. And I think consistent with that point, that's one of the things that is frustrating to me, is that they do have 20 of the 22 ECDs, but they haven't even submitted half of the applications. And we're looking at 20 of the 27 wells that would apply to. And I agree. I think that even if you're looking at giving additional time, there is a concern with, well, if you're already facing this regulatory time frame to get the applications in, you may be looking at a significant amount of that time to do it. Again, I think the lawyer in me wants to say they haven't met their burden. That's it. And it sounds like we have two others that are kind of in that boat. And so I'd be tempted to go that way, even though I do have, an appreciation for wanting to provide that time. But I don't think that they've met their burden to be granted a variance request at this time. You're on mute, Mr. Chair.
Commissioner Ackerman, Commissioner McGowan, I like how we deliberate and try to listen to each other and make sure that leads us to the right decision. You've heard from three of us with the potential for a sort of kind of, maybe there's a little room there, but there's also three commissioners willing to take it up on the merits today, which is what we're supposed to do. And we can also just have a motion and we can just see where that goes. But I did want to give you one last opportunity before we move into the motion stage. Commissioner Ackerman.
Thank you, Mr. Chair. I appreciate the follow-up there. And I am compelled by the thoughts of my fellow commissioners here as well that are more experienced than I am in this matter and certainly have more of a history with this matter, together with the caution that I feel associated with this operator. I am compelled to agree that it's unfortunate, but that the burden has not been met in this hearing.
All right, Commissioner McGowan.
Thank you, Mr. Chair. And after listening to my fellow commissioners, I have to say that I agree. I'm not sure they've met the burden for a request for a variance, but I am empathetic to what has happened to this operator and, attempts to try to rectify the situation that they're in. But I think to the points of other commissioners today, the bar to jump over for asking for a variance perhaps has not been met today. And that is what we're considering.
Does any commissioner care to provide a motion?
Mr. Chair, I'll move to deny the variance application as presented.
Second.
Motion and a second. Is there further discussion? Commissioner Messner?
So I will note that there, at least to my understanding, there's not an impossibility for an applicant to ask for a variance twice. And so I would strongly suggest that should this operator be interested, that they take some time, develop a plan, develop a timeline, get permits in hand, develop the necessary information to show good intent to comply. And it is possible that there is consideration for something like this, but unfortunately today, as presented, it was, from this commissioner's standpoint, the burden of proof was not met. And I think that was unfortunate. But I'll leave it with that thought, I think.
Further discussion on the motion? Commissioner Ackerman? No, you're just waiting for the vote. Okay. All right. With that, all those in favor of the motion signify by saying aye. Aye. Any opposed? Okay, motion carries. Again, want to thank the applicant for the presentation, and we will leave it at that. With that, I believe we have come to the conclusion of our business today. Is there anything further from any commissioner? Seeing nothing, we would look for a motion to adjourn.
So moved. Second.
Couple of motions, at least 1 second. All those in favor of the motion signify by saying aye.
Aye.
All right, we are adjourned. Thank you, everyone.